Good morning. This is the Wednesday, January 24th, 2024 edition of the Colorado Energy and Carbon Management Commission Business Agenda. We will start with a roll call.
Thank you. Commissioner Ackerman. Commissioner Cross.
Present.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Oath. Commissioner Ray. Commissioner Robbins.
Here.
Mr. Chair, you have 5 of 7 commissioners present.
Great. That's quorum. Good to see everybody. We've got a hearty slew of business today, so let's get into it. We start with commissioner comments. Does any commissioner have comments for the good of the cause? Seeing none, we're anxious to jump right into our agenda. We next would entertain public comment. We had 2 people sign up originally and then 2 more subsequently, Marcia Goldsmith-Cammon, and we also have Mark Goldsmith-Cammon. We also had as late signups Robert Ness and Ada Stapleton. I'm not sure if they were wanting to testify as general public comment or to one of the items on our agenda, but we'll give everybody the opportunity to be brought to the fore here now. You're probably looking for them, hearings manager Thomas.
Yes, currently no sign of Mr. Nass or Ms. Stapleton, but I will alert you if they appear and elevate.
What about the Mr. and Ms. Cammon?
They are both elevated and just need to unmute and they can begin.
Well, hello.
Good morning. My name is Marcia Goldsmith-Cammon and I live in Aurora. I wanted to address 3 areas of the ECMC cumulative impact rulemaking process. The first is scope of the rules. Why is the scope limited to within 1 mile and excluding transportation when oil and gas pollution travels further and impacts communities beyond this narrow zone? Will you consider expanding the scope to address these broader impacts? In fact, most of the sections throughout the rules indicate residential building units within 2,000 feet, such as in the pre-application consultation. There are countless scientific studies showing that pollution particulates travel further than 2,000 feet. Densely populated communities that will be impacted by the pollution caused by oil and gas can be much further than 2,000 feet. And the horizontal well bores travel 3 to 5 miles underneath residential buildings and schools. If any of these pipes leak up to 5 miles from the well pad location, as data has already shown this has happened, public health will be affected a lot further away than 2,000 feet. Ozone pollution. The proposed rules don't effectively address nitrogen oxide pollution, a key contributor to ozone. What steps will be taken to strengthen consultation with the Air Quality Control Commission, set emission thresholds, and link permit approval to meeting these standards? Setting specific thresholds is a critical component of the oil and gas approval process. Industry must be held accountable so as not to exacerbate ozone non-attainment areas. And this concept also applies to the greenhouse gas emissions. Setting intensity targets as mere considerations for new permits seems insufficient. Given the low production requirements, this could essentially allow unlimited pollution. Why not establish stronger emission thresholds and tie the permit approval to meeting them? New permits should not be granted in communities that are already burdened by pollution. No new permits should be given if levels of emission of ozone precursors and greenhouse gases will go over the limits set by law and by the governor's executive order on nitrogen oxides. Thank you for giving me the opportunity to address these critical components.
Thank you. We appreciate you being with us today. We'll make sure that your comments are incorporated into the cumulative impacts rulemaking docket. Did we have Mark Goldsmith-Cammon? There you go. Hello.
Yes. Good morning. I'm Mark Goldsmith-Cammon, a resident of Aurora. My topic this morning is the January 17th straw dog, or draft of the ECMC cumulative impacts rules. There are many parts of it I'd like to address in the future. But at this moment, I'd like to simply address the very first section of the draft titled Definitions. I find it hard to understand why the Commission has chosen to hamstring itself by limiting every definition to such a narrow scope. According to SB 19181, the ECMC's mission is to protect and minimize adverse impacts to public health, safety, and welfare and the environment, and to address potential cumulative impacts of oil and gas development. This directive does not contain any limits, such as the draft statement, quote, within 1 mile of a proposed oil and gas location, unquote. The cumulative impacts of oil and gas operations are seen across large swaths of our region and state and must be addressed as a whole to effectively meet the intent of the law. I also wonder why the proposed rules are so narrowly focused on AQCC regulation number 7 for environmental concerns, such as greenhouse gas, nitrogen oxide, and ozone targets. There are other sources to consider from the EPA, as well as requirements being driven down from our governor's office, such as the 2023 Nitrous Oxide Management Directive, that are not yet fully embodied in any agency regulations. The proposed cumulative impact rules are also expected to be used far into the future, and therefore should be allowed to accommodate any improvements incorporated into future laws and regulations, instead of limiting them to rules in effect prior to April 28th, 2024. It's imperative that the ECMC use a broader scope of definitions to address cumulative impacts, since these will ultimately have a major impact on the effectiveness of the entire approach being used to meet the mission of protecting the public health, safety, and welfare in the environment. Thank you for listening this morning.
Thank you, Mr. Cameron. Again, as noted earlier, we'll make sure that your comments are incorporated into the cumulative impacts rulemaking docket. We appreciate you being with us this morning.
Appreciate that. Thank you.
All right.
Mr. Chair,
Yes.
I just, to one of the last comments from Mr. Cameron, I just want to throw out there that there are specific dates tied to rules from other agencies, because that is required as part of our, I think it's APA requirements. You can't have an open-ended rule that just keeps updating as someone else updates the rules. It has to have a date attached to it. And so I just want to let folks know that there's a reason why there's a specific date in the draft rules tied to what CDPHE has done for greenhouse gases and NOx. And I'm sure that will come up when we have our discussion for the straw dogs, but for folks who are listening, I'd really just want to make sure folks understand why that's in there at this point.
Yep. Good point. Thanks for raising that, Commissioner McGowan. All right. Hearings Manager Thomas, Mr. Ness and Ada Stapleton, they're not around. Is that right?
We did see Robert Ness in the attendees. However, he declined multiple attempts to be elevated. So,
okay. Then perhaps he wants to speak to Coyote Trails or one of the other specific dockets, and we'll look to elevate him at that point. All right, that takes care of public comment. We then move to the next item on our agenda, which is the consent agenda. Does anyone have questions with regard to consent? Seeing no questions, do we have a motion to approve consent? So moved.
Second.
Motion and a second to approve consent. All those in favor signify by saying aye. Aye. Consent agenda is approved. We now will move to the next item on our agenda, which is an enforcement staff update, guidance, and rule clarification. And I believe that this is going to be presented to us by Stephen Kirshner, the enforcement supervisor. Good morning, Mr. Kirshner.
I'll be brief. We asked for just a little bit of time on the agenda today to highlight a recent revision to our enforcement guidance and our rule classifications.
Hey, Mr. Kirshner,
yeah.
Hold on just a sec. You sound like you're in under like 10,000 feet of water. I'm not sure if you can adjust the audio.
How about this?
It's 100 times better. Now you're above water and breathing air. Congratulations.
Perfect. Yeah, thanks for letting me know. So we did ask for a little bit of time on the agenda today to just highlight a recent revision to our enforcement guidance and rule classifications. As you know, the guidance provides an overview for the public and the regulated community about the various steps and pathways of the enforcement process. So prior to this year, the most recent update to our guidance occurred in 2015. A couple of things have obviously changed since then. So late last summer, our team began redrafting this guidance to reflect not only the new rules that have been enacted, but also putting into writing some of the processes and practices with which our stakeholders have become familiar over the last few years, but may not have been mentioned in that existing guidance. The most important takeaway I want to leave you with is that this was an iterative process. This was an evolution. It's not a revolution. We're not talking about sweeping changes here. Most of the enforcement specific rules, those are in the 500 series, those have changed very little since the 2015 guidance. Just to hit some specific points of the new revision, as I mentioned, we've added discussions of some of the processes that have been developed and implemented since the last revision. Those include the hearing officer process with the recommended orders and batch NOAV prosecutions. Those have come before you through enforcement of such rules as the 1101B flow line prosecutions, Form 1B, Form 3 filings, things like that. We've also added some additional details on the petition for review and the exception processes. Since that last 2015 update, we have commission orders, we have hearing officer orders, as well as extensive briefing to draw from in laying out guidance on petitions for review and exceptions. We've also taken the time to explain the stipulated order finding violation process with which the commission's become familiar. This has become common these days, but it wasn't really contemplated in the 2015 guidance. We also described cease and desist orders and orders pursuant to Rule 901A and the distinctions between those orders and when each of those are appropriate for enforcement staff to use. Those 901A orders are new since the last guidance revision. We expanded the section on penalties, specifically regarding how enforcement staff has historically looked at impact factors where a violation leads to minor actual impacts. And finally, we added some context on aggravating and mitigating factors as they apply to penalty calculation. Most notably here, we're talking about patterns of violation, self-disclosures, and prompt and effective responses by operators to violations. Again, this added context is consistent with the way our enforcement staff has historically approached these issues and regularly approaches these issues. So that's kind of the high points of the guidance revision. Regarding the rule classifications, as you know, we have 3 classes of rules. The class is one of the variables involved in calculating a penalty for rule violations. So we've gone through and we've sorted the rules into those 3 classes. Now, again, this is largely an iterative update necessitated by the volume of new rules and the shifting of regulatory requirements between rule numbers. These new classifications generally track with the 2015 classifications. In other words, probably no surprises here. As we did update these, enforcement staff engaged in consultation with the managers of each of the various units. These are the folks who know the rules best. They interact with them daily. We had a number of productive and collaborative discussions leading to these new classifications. And finally, I should add, where we did change a classification of an existing rule, we almost exclusively bumped those rules up based on the experiences we've had over the last few years since the prior guidance revision. So those the updated guidance and the classifications went live on the website yesterday. They can be found under regulation enforcement. I just want to take a moment to recognize all the folks who made this happen. This was a big lift involving a lot of people, most notably our enforcement team. Specifically, Jeremy and I want to recognize Sierra Schroeder. She's one of our newer enforcement advisors for her drafting work, and Kelly Rosenberg and Caitlin Stafford for their edits and their thoughts. I want to thank all the managers for their input on the rule classifications and their discussions with us throughout this process. And finally, I want to thank you for your input, for time on the agenda today, and the opportunity to highlight the guidance revision. And that's all I've got.
Great, thank you very much. If you don't mind, let's stand for questions here. Do commissioners have questions? Well, you did a great job of explaining yourself because there are no questions. Thank you very much, Mr. Kirsten.
Thank you, Mr. Chair.
All right. Next on the agenda is a tentative break, but we've only been going for 15 minutes, so why don't we keep going and plow through another item. The next docket number is 211100229. This is a variance request. The applicant is Evergreen Natural Resources. If we could elevate Mr. Wackerlin and Mr. Cohen as attorneys for Evergreen, as well as any of their potential witnesses. Good morning, council. Do you have witnesses that you're going to be asking questions of today?
We do, yes. Michael Joy from Evergreen. Looks like he's elevated as a panelist, at least from my view.
Then we will have Assistant Attorney General Davenport swear in the witness.
Thank you, Chair. Mr. Joy, could you please visualize yourself and unmute yourself as well, please?
Morning, Mr. Davenport. I thought I was visualized, but maybe I'm doing something wrong here.
I can't see you. I don't know if it's just my computer or...
Let's try that. There we go.
There we go. Perfect. Sir, would you please raise your hand, state your name, and say that you swear to tell the truth?
I'm Michael Joy, President and Chief Operating Officer of Evergreen Natural Resources, and I swear to tell the truth at this morning's hearings.
Thank you. Mr. Chair, I believe we're ready to proceed.
Very good. Mr. Cohen, the panel is yours.
Thank you, commissioners. Let me share my screen to pull up the PowerPoint presentation that we've prepared. Can you all see that?
We can. It's not in presentation mode, if that matters.
Interesting. How about now? Still no?
Still no. It's
All right. 1 second. Apologies. Okay. How about
now you're good.
Great. My name is Jordan Cohen with Brownstein Hyatt Farber Schreck. With me today is Eric Wackerlin, also from Brownstein, and Michael Joy, the president and CEO of Evergreen Natural Resources. This matter concerns a variance request to the recreation requirement of Rule 1004C. The recent background in this matter is that on April 25th, Evergreen submitted its most recent variance application to keep the well pad and the access road in its current condition per the requests of the surface owners. On June 14th, ECMC staff requested 2 conditions of approval that required installation of BMPs at the site. On June 28th, 2023, the landowners submitted a comment letter into the docket opposing the additions of these BMPs and also refusing Evergreen access to perform the requested BMPs. And on October 18th, staff issued a conditional director's recommendation recommending approval of the variance with the conditions of approval that are opposed by the surface owner. This slide shows just brief excerpts from the comment letter that was submitted by the surface owners stating that they didn't feel that the requested BMPs were needed and also refusing Evergreen access to perform them. This puts Evergreen in a position where, in order to comply with the conditions of approval, it would need to trespass on the surface owner's property in order to install them. And now I'll call Mr. Joy to further testify about the location.
Thank you, Jordan. I think my testimony will be relatively brief on this issue. This iteration of Evergreen, as well as our predecessors, Pioneer Natural Resources and the original Evergreen, one of the things we've done very well is work closely with the landowners in the Raton Basin to try and develop the field in a way that benefited them to the extent that they could. And one of the ways that many of our property owners feel as though they've been benefited is by the infrastructure improvements on the land. And this is one of those cases. The current property owners are the Luce family based in Texas. They were not the original owners of the property when the field was developed. That was the Day family. The well in question was plugged and abandoned in 2013, in June, July of that year. And plugging and abandonment was signed off by the then COGCC, I think on January 3rd of 2014. So a little over a decade ago at this point. At that time, the Day family had requested a variance, and what they wanted the company to do, and what Pioneer did, was to leave the access road that goes up a nice little valley to the well location, which is a flat building area. The Pioneer reclaimed about half of the location, reclaimed the pit that was on location, and essentially left it in a condition where it could be built upon. The Days owned it until I think 2021 or early 2022, when they marketed and sold the property to the Luce family. And the Luces have stated to us, to Bob Lucero, the county planning commissioner for Los Animas County, and I think in their written correspondence to the ECMC, that part of the reason that they bought the property was because of the infrastructure improvements on it. They used our then access road, is now their access road, and they use the location, and they're intending to build a cabin on it, or at this point, they may have even started doing so. I don't know. What I do know is that they contacted the county planning commissioner for building permits to inspect the site. That's been done. As part of the county's development process, they also have stormwater considerations and concerns they take in to the permitting. And the Luces have denied us, as the company, access to their property, which of course they have the right to do. We have no legal right to trespass on their land, on the basis that they want the property left as is. It's a collaborative, cooperative relationship. This particular landowner is not hostile to the company. There are others in the Raton Basin who are more hostile to us on these kinds of issues. The Luce family simply just wants to be left alone from this issue at this point. They have told us that if we were to go in and do some of the work that was requested, including some of the BMPs on stormwater, that they're taking them out, that they intend, and they have a legal right to build the road just as it is, to the location just as it is, and that's what they're intending to do. And so the company finds itself essentially between the ECMC and the property owners at this point. And so the variance request that we're making is really to honor the requests, the intentions, and the future property owners as the property owner.
Thank you, Michael.
Certainly.
To conclude, we request that the commission approve Evergreen's variance application without the conditions of approval requiring installation of the additional BMPs requested by staff on June 14th, 2023.
Does that conclude your presentation, Mr. Cohen?
It does, yes.
Do you want to run through how it is you believe that your client has met the 5 findings that we need to make?
Sure. That is outlined in the variance application. Let me pull that up and I can run through them for you. So under 502C of the ECMC regulations, the commission can grant a variance if the applicant has made a good faith effort to comply or is unable to comply with the specific requirements contained in the commission's rule. That's really what's happening here, is that Evergreen is unable to comply with installing these BMPs because it doesn't have access to the site necessary to install them. We also would assert that approving the variance does not violate the basic intent of the act. There's no adverse impact to public health, safety, welfare, the environment, or wildlife resources. And the requested variance contains reasonable conditions of approval or other mitigation measures to avoid, minimize, or mitigate adverse impacts to public health, safety, and the environment. Really, these conditions of approval, if added to the variance, would be impossible for ENR to do legally, and would put them in an untenable position where they would either need to trespass or risk being in violation of the ECMC's regulations. So that constitutes sufficient undue hardship that would justify granting the variance here.
Okay, thank you very much. At this time, I believe the applicant has rested his case, and the applicant and his witness is open for questions from the commission. Commissioner Messner.
Thank you, Mr. Chair. My understanding is that the applicant are asking for the variance to be approved without the conditions of approval, and part of the testimony that I think was provided that justifies the not need conditions of approval would be the government disposition and the local government permitting. But in the review of the, is that me that's doing that, or? Okay, sounds better. In the,
I think if Mr. Joy put his microphone on mute, then it would be easier to hear you, Commissioner Messner.
okay, that'd be great. So in the submittals that you've provided, what I can see from a local government perspective is some documentation around reclamation and variance considerations, but I'm not seeing any specific land use planning documents that would, you know, put stormwater management controls associated with driveways or any kind of site considerations associated with building pads or things of that nature. So am I missing something there? That seems to be part of your testimony, and maybe I'm just missing it, but that local government disposition seems to be relatively important as we're talking about that taking the place of some of the conditions of approvals.
Michael, are you able to speak to that question?
I can speak to it. I wasn't certain it was being directed at me. Commissioner Messner, I do not have the local permitting applications that the Luce family would have submitted. I have not gone out and requested that information. It comes to us through the Luce family, and the fact that, frankly, Los Angeles County is not that large. We know Planning Commissioner Rob Lucero pretty well, but no, we have not requested that information. And I don't think it changes the fact that the property owners have denied us access. And you know, from the company's perspective, we feel like we're in the bit of a middle here. The well was abandoned in 2013. The Day family used the property. It was their property to use until they sold it to the Luces. We really had nothing to do with that. I think this was brought to our attention that the original variance application had been pending for years, candidly, and had somehow been taken off the docket. Again, a process I don't understand. And it came to us through, I believe it was a CO or ECMC at that point, probably inspection in 2021 that would have resulted in Evergreen going out, meeting with the property owners again. Likely would have been meeting with Mr. Lucero, though that person is no longer with us. They're not with the ECMC, actually. And us resubmitting the application in 2022. So I can give you background on the extent of what the property owners have told us, but the fact remains that we've been denied access to the property.
Thank you.
Further questions of the panel, Commissioner Ackerman.
Thank you, Mr. Chair. Just one question, Mr. Joy. Thank you for your testimony today. And just my question is intended to rule out a specific concern that might be raised in regard to these types of situations, not you specifically, but has there been any consideration offered to the landowners from Evergreen via financial compensation promises or any other material discussion that could be construed as a financial benefit offered from Evergreen to the landowner in exchange for not reclamation? Or would you say that this is entirely the desire of the landowner absent any other type of compensation?
Commissioner Ackerman, Evergreen has absolutely not offered any compensation to this landowner or to any other landowner in the Raton Basin for any type of these considerations. We're very sensitive to both the ECMC and before that COGC seems concerns about that issue. All Evergreen is trying to do is work with the property owners in the Raton Basin as collaboratively as we can. And frankly, we have a very, very good relationship with our landowners, while also, of course, meeting the ECMC requirements. This is entirely driven by the property owners and the desires that they have. And I think it's related to your question. Putting in BMPs of gravel bars for stormwater erosion and those things is something that Evergreen does in the ordinary course of business all the time. It's not something we have any intention of avoiding or trying to avoid, or that benefits us in any way. This is simply about the request of the property owners to use their property as they want to.
Thank you for your response, Mr. Joy. Very helpful. I appreciate that. Nothing further, Mr. Chair.
Great, good question. Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Mr. Joy. Related to the comment that you made that the well was abandoned, I think plugged and abandoned in 2013. Is that what you said?
Yes, that's correct, Commissioner McGowan. I actually read the abandonment report immediately before this morning's hearing, and I believe it was in June or July of 2013 that the well was plugged, abandoned, capped, buried, and then they did a partial reclamation of the location that's in the hearing record as well. They shrunk the size of the pad about in half. There had been a production pit there as well that was covered and reclaimed as well. They reseeded the location using a seed mix at the request of the then Day family that owned the property. And so everything that the property owner had requested was done.
And at that, thank you. At that time, were BMPs put along the road to prevent stormwater erosion? I think what our staff is trying to get at, there's certain BMPs that we require. Even if you're asking for a variance, many landowners say, I would like to keep the access road. I would like to keep a pad because I use them for other purposes. Usually we see those BMPs get implemented before the operator then parts ways and comes to the commission and says, we'd like a variance. And I'm wondering if this has gotten to this point because it's taken so long to get to those BMPs, then they didn't get implemented. I'm kind of empathetic to the landowner. We're like, oh, this happened in 2013. I've been using my property this way. Why is this an issue now? And so I'm kind of trying to understand whether or not those BMP, stormwater management BMPs, were put in originally in 2013 when you plugged and abandoned the well.
My understanding, Commissioner McGowan, is BMPs were put into place in 2013 when the well was plugged. As I understand, and that, by the way, comes from reading documents that are in the record. They go in and explain everything that was done at the time. And as far as I can tell, again, I wasn't there in 2013. This wasn't a controversial issue, and it remained opened and unsettled for a significant period of time. And I don't know why. I understand from the inspector's recent inspection, which I think was in 23, that what they observed was some rockfall on the slope, which in the Raton Basin is a fairly common issue, not surprisingly. And I believe what they viewed as some water erosion on the road, which again would be a fairly common thing. Property owners do road maintenance for those issues all the time in these semi-arid environments. But there was no issue with the construction of the BMPs at the time.
And sorry, it's been a while since I read the materials. We've had a lot on our plates, so apologies. But after the original work in 2013, I'm trying to remember the documentation and the correspondence back and forth between Evergreen and the landowner, the first landowner. I think that there was at that point in time, there was an original idea to ask for a variance to keep the road and the pad, correct? And
Correct.
so it's kind of been circling the airport since then. And now we have these additional conditions, not additional, but conditions of approval that our staff would like to see before they can close it out here. And then the current landowner saying, we're done. We feel like we just want things left as is.
That's correct. After the well was plugged and abandoned, and the reclamation work was done in 13, there was an application then submitted by Pioneer Natural Resources for a variance. I cannot speak to why that wasn't acted on over the course of time. Sometime in 2020 or 2021, the then owner of the property, the Day family, marketed it for sale. And the Luce family out of somewhere in Texas came in to buy it. And they told the prior owner, as well as telling Evergreen's land and regulatory departments, that they were buying it to build a cabin. And so the improvements that they think of as structural or infrastructure improvements are in fact the access road and the pad as it is. They're putting a cabin there is what they're doing. And so they closed on that sale, and it's now the Luce family who, again, they're very nice people as far as I know. This is not a hostile or controversial relationship, but they said, we bought this property to build a cabin, and we're denying you access. You have no right to come in here and interfere with our property. They've gone further, and again, I don't want it to sound like it was hostile or confrontational, but they've said, we have the right to build this road. We have a right to build this location. We've met with the county planning department on this. If you put this in, we're taking it out. And so, we as the company have to go through the variance process to try and resolve the issue. We, of course, don't want to be between the property owner and the county and the ECMC on this.
Thanks. I appreciate your testimony. I guess I think it's unfortunate there's a landowner who doesn't desire BMPs that will prevent further erosion on their own property, but that is also someone's decision to make. So thanks for the information.
Commissioner McGowan, I would just add that as a matter of the record, there's a letter from all kind of three landowners, Patricia Day, who was the previous landowner to the Luces, that kind of details, essentially requesting a waiver for full reclamation and asking in part for, at that time, Pioneer to provide some interim seed mix. And then the other two letters from the Luces and the Days kind of detail the actions that Pioneer and then ENR has taken to kind of implement the BMPs up to the point that they can, which includes, some stormwater related stabilization and that kind of thing. So it's all in the record that kind of ENR has walked up as far as they can to the line to, respect the landowner's wishes, but they have been actively conducting kind of stormwater related BMPs on the property. And from my conversations with folks at Evergreen, even last year when we filed this, the property owners are very happy with the work that ENR's done up to this point.
Thank you. I think when you read the correspondence, it's difficult to tell. I mean, I think to Commissioner Ackerman's point, if the operator was pushing, because the way that it's written is we exempt ourselves from any liability now, and you understand that this is what's going to happen, kind of a thing. And so it's helpful to get kind of the background story about why the correspondence was written and the context of the correspondence. So that was helpful. Thanks.
Further questions? All right, seeing no further questions, we move into the deliberation phase of this matter. Does anyone care to initiate deliberations? Commissioner Messner, then Commissioner Ackerman.
Thank you, Mr. Chair. And I'll start by saying that generally speaking, I'm in support of the different considerations that a landowner may have and desires that they may have, and the ability for us to be able to approve variances to maintain some of the access roads, maintain some of the pads, be able to provide some benefit to landowners. But as part of that, there's a requirement that there be clear best management practices that get employed on that prior to, approval of that variance, to ensure that the variance that is being approved is protective of public health, safety, welfare, the environment, and wildlife resources. In this particular instance, I'm unclear whether or not this operator has clearly met the burden of proof to determine whether they are protective. And part of that is not the fault of the operator. I do believe that the operator has a desire to actually come in and do these things, but there's a problem with the landowner who's unwilling to provide access to the operator in this particular situation in order to be able to employ some relatively simple mitigation measures and then be able to approve a variance and hand it over to the landowner as an improved and protective variance. And so I struggle with this one a little bit, and I think the landowner needs to take a lot of responsibility for that. And so it's my opinion at this point, because there's no documentation that's been provided by the county that shows that the county is going to require certain best management practices or stormwater management controls to this particular location. And it could be that they do have requirements or have permits in hand that would be able to make a showing that that's the case. And that may actually make staff's requests, ECMC staff's requests, null and void as to the BMPs that they're proposing, but nothing's been provided that would make a showing of that. And so I am in support of this variance, but I'm in support with the conditions of approval that are brought by staff, as I don't have a clear record as to why they would not be required if staff's expert opinion believes that they're necessary and reasonable to include in this variance application. So those are my thoughts.
Commissioner Ackerman.
Thank you, Mr. Chair. And I think that was well stated by Commissioner Messner. I would just add that, we have a private property rights issue here as outlined by Commissioner Messner. And I think a lot of people, when they listen to that, they think, well, that should be the end of it. The private property owner wants X, right? And we do very much respect the ownership of private property in Colorado. I do think it's important to understand that a lot of our regulations are based upon the larger health and well-being of the state and its environment as a whole, and that, as in the case of this property does switch hands from time to time, and the desire of the current property owner could have significant impacts on future owners and future well-being of the environment, particularly in high priority habitat here. That said, I agree with Mr. Joy. This is a rock and a hard place. I appreciate Evergreen's efforts to make this happen, their willingness to make this happen. And I suspect that if the landowner changed their mind, that Evergreen would make this happen in compliance with our regulations. For that reason, Mr. Chair, I find it difficult to not be in support of the variance.
Thank you, Commissioner Ackerman. I tend to agree with that line of thought. I believe that our variance procedure here is set up to allow this commission to weigh, as you stated, kind of the larger health and well-being relative to the state. And when I look at a variance, the implications are not to the larger health and well-being, but really are just basically to this private property owner, then I tend to favor the private property owner's private property ownership rights. And I'm not seeing that the additional COAs are relative to kind of the larger health and well-being, as opposed to just relative to this particular piece of property. And so I also am in favor of the variance without the conditions of approval. Commissioner Cross had raised his hand.
Thank you, Mr. Chair. I'll just be brief and say I agree. And with one point to what Commissioner Ackerman said, I think that there are situations where property does change hands. And so it not having those conditions of approval could affect future landowners, but at the same time, we can't guarantee that there will be future landowners, which I think also provides a little bit of difficulty in the situation. And as you noted, Mr. Chair, I think looking to what the property owner wants in this situation, I think is important, especially given the insinuation that they will remove some of the efforts taken. I don't think that that's something that we will ultimately have control over after it's done. And so I tend to look to the private property owner as well, who would be in favor of the variance without the condition.
Others with deliberative thoughts? Does anyone want to make a motion?
I would move for approval of the variance absent the conditions of approval.
We have a motion. I'll second the motion. Do we have deliberations on the motion?
Mr. Chair, I'll reiterate that I don't have an issue with the variance in general, but I'm not sure that there's been any record developed to supersede staff's recommendations on their conditions of approval. And so I'm going to vote nay on this particular motion, but not on the variance in general, as I indicated in my initial comments.
Thank you very much, Commissioner Messner. Commissioner McGowan?
Thank you, Mr. Chair. I'm going to vote on the motion as stated by Commissioner Cross. Part of the other sticky wicket for me is the time from the original variance request to now and today. And I think the landowner is justifiably probably flummoxed as to why we're involved at this point in time on a property where things have grown in and have been used. And I think that's a disservice to ourselves and to the property owner. I'm also going to follow up on, I think it was Commissioner Cross's comment. If we go in and require it with a landowner who doesn't want the operator on the property, and then who says or states or someone says they're going to remove the BMPs that get put there anyway, I just don't know, even if we kept the condition of approval, if what we think would be helpful and protective from a stormwater perspective is actually going to be of any use if it gets removed. So I will be a yes vote on the motion.
Commissioner Ackerman?
Thanks, Mr. Chair. I just wanted to add a couple of comments similar to Commissioner McGowan's and was going to state essentially the same thing. The more than insinuation, the statement that the operator or that the landowners would remove any improvements makes this an exercise in futility. I do note that it would be important, at least to me as a commissioner, that any actions taken are in compliance with local land use codes and any other, local rules that are in effect with regard to land use manipulation. But I will also be a yes vote.
Further deliberative thoughts on the motion? All right. All those in favor of the motion, and then I'm going to say all those against the motion so that we can create a correct record. So all those in favor of the motion signify by saying aye. Aye.
Aye.
And all those against the motion signify by saying aye.
Aye.
All right, the motion carries 4-1. The variance is granted without the conditions of approval. Thank you to the panel. Thank you to staff for their input on this important docket. Let's take a 10-minute break and return at 10 a.m. for our next matter, which is the Myrick Verdad matter. We'll return at 10. All right. Welcome back, commissioners, to the Energy and Carbon Management Commission hearing on January 24th. It is 10 a.m. We will recommence our proceedings and we will take up docket 2212-00371. This is a general administrative type matter. The applicant are the Myrick and Ms. Woodby, and the petitioner is Verdad Resources. Would first recognize AAG Davenport to deal with a late filing that happened last night.
Thank you, Chair. Commissioners, I'm aware that you received a written public comment late yesterday in regards to this matter. The chair has asked for my thoughts, and my thoughts are it's not appropriate to consider that public comment in this proceeding for two reasons. The first is this is an exception to the hearing officer recommended order and should be based on, and obviously the order and the legal arguments, but also the record and what was presented to the hearing officer upon which the hearing officer based his recommendation. The second is The commission hearing on the merits of this matter has already passed in the terms of, or the portion where the parties provide their arguments to you. While regardless of the first point, it may have been appropriate to accept public comment back then. Now the commission's received all its information, and the only portion of this hearing that's left is deliberations. Any decision. I don't think it's appropriate to consider a public comment so late filed. The public comment could have been filed much earlier. In fact, it could have been filed with the hearing officer and allowed the hearing officer to make a decision in consideration of that comment. But since none of that was done, my recommendation is to disregard that comment that was submitted to you yesterday.
And the comment is from whom and on behalf of whom, just so we can identify it?
I did look at the comment. The comment is filed by a non-party HRM. It is in support of the MYRIC's position in this case.
Okay. I'm comfortable accepting the advice of legal counsel here to not intertwine in the record the late filed public comment. Is anyone against that position? All right, seeing none, then we will disregard the late filed public comment on behalf of HRM, and we will move toward deliberations, commissioners. I think that we have the written record before us. We had the oral argument, and now it is up to us to deliberate on the exception to hearing recommended officer order denying the Merrick's motion for summary judgment and granting Verdad's motion for summary judgment. Does any commissioner desire to lead off? Commissioner Cross.
Thank you, Mr. Chair. And I'll say in advance, if you have a problem hearing me, please let me know. I realize I'm in a slightly different setup than I normally am. And so please let me know if you cannot hear me. I will say that my deliberative comments are fairly lengthy, but I'll try and be as brief as I can. The commission has been tasked with an uncommon decision in this matter. It is not often that the commission engages in contract disputes. However, decisions and contractual disputes that come before the commission are often passed on because of disagreements concerning contractual interpretation, a decision for which this commission does not have jurisdiction. Here, to the contrary, we're faced with a disagreement about statutory interpretation, which is within our jurisdiction. I believe it's important to first address the commission decision in the Catamount case. The ultimate issue there was whether the payment of overriding royalty interest carved out of non-consenting working interest had to be paid during the statutory penalty period. The commission found that it did not, and I see nothing in the arguments to change that determination here. However, I believe that there is much more at issue. While I believe the decision of the commission was correct in Catamount, I do not agree with the commission's interpretation at that time of Colorado Revised Statute 3460-116-7A. To explain my reasoning, I'll first address applicable cases. The Colorado Supreme Court has unequivocally indicated that an overriding royalty interest is similar to a royalty, as it is, quote, an interest in oil and gas produced at the surface, free of expense of production. That comes from Garmin versus Conoco, and excuse me for not providing the full legal citations here. The court went on to state that both royalty and overriding royalty interest are, quote, non-risk and non-cost bearing interest. This characterization was not made off the cuff, but rather consistent with the oft-cited and highly regarded oil and gas law treatise, Williams and Myers, as well as being consistent with more than 2 decades of Colorado case law, the Haygood case cited by both parties here. In Garmin, the Supreme Court specifically found that while all parties, even mineral owners, should share in costs to enhance the value of oil and gas that is already marketable, overriding royalty interest, like royalty owners, do not share in costs to make the product marketable. Notably, the Supreme Court characterized royalty owners and overriding royalty interest owners as non-working interests, as compared to working interest owners, which are risk-bearing parties. Thus, while there are distinct differences between royalty owners and overriding royalty interest, including the ability to extinguish overriding royalty interest, case law is clear that the interests are similar in that they are non-risk and non-cost bearing. Despite this well-established understanding that overriding royalty interests do not bear the risks or costs of development, we must look to the statute to determine if there is legislature has decreed a different meaning. The Oil and Gas Conservation Act does not define or characterize overriding royalty interest, thus the Supreme Court's descriptions would still apply. While Verdad acknowledges the court's definition of an overriding royalty interest, it states that the definition is not dispositive of the legislature's interest in the applicable statute. Verdad argues that the purpose of Section 116(7)(a) is to allow consenting working interests to recover their upfront drilling costs from non-consenting working interests while protecting the mineral owner's royalty that is to be paid on the non-consenting working interest owner's lease. I do agree with the first part of this alleged purpose, but not the qualification of the latter part. I'll explain my reasoning shortly, but before I do, I note that Verdad goes on to state that the interest of the legislature was to, quote, distinguish between working interests, which are subject to recovery and penalty, and mineral interests. And then, quote, use of the phrase royalty or other interest not obligated to pay any cost is intended to protect the mineral owner's royalty and similar interest created from the mineral interest. Now, a key argument made by Verdad and Catamount and the Commission in 2017 is that the legislature understood the difference between royalty interests and overriding royalty interests, and had they intended to mean royalty interest, overriding royalty interest in Section 116, they would have done so just as they did in Section 118. I admit that this is a persuasive argument, and the failure of the legislature to include language that is used in other statutes can be dispositive of the meaning and or intent. But I do not believe that is the case here. Let's begin by looking at Section 118. In both subsection 5 and 6, the legislature lists royalties, overriding royalties, and production payments as, quote, interests which are free of cost. While the legislature does not similarly list overriding royalties in Section 116, Verdad's reliance on this fact suffers two flaws. First, the legislature here recognized that overriding royalty interests are comparable to royalties in that they are free of cost. Thus, the legislature has acknowledged the Supreme Court's characterization that overriding royalty interests are not cost-bearing. Second, and I believe far more important, is that the language is clear in Section 118 that these are illustrative examples. In subsection 5, the legislature identified interests that are free of cost, quote, such as royalty, overriding royalties, and production payments. In subsection 6, the quote, royalty, overriding royalty, and production payments, quote, and other such interests which are free of cost. The use of such as and other such both shows that these interests are examples of non-cost-bearing interests and demonstrates that the list is not exhaustive. Turning to Section 116(7)(a), the legislature excludes royalty or other interests not obligated to pay any part of the cost thereof. Again, the legislature failed to provide an exhaustive list, instead leaving the commission to consider, quote, other interest that is not cost-bearing, which, as we have seen, and the legislature has agreed, includes overriding royalty interest. While I agree that the legislature could have included overriding royalty interest in Section 116, as it did in Section 118, it could have just as easily accepted or excluded overriding royalty interest. Or the legislature could have just as easily specified that it meant non-participating royalties and severed royalty interest, which Verdad argues was the legislature's intent in 116. Had the legislature provided an exhaustive list rather than an illustrative list in Section 118, Verdad's argument would carry more weight, but the use of such as in Section 118 does not convey that the legislature could not have included overriding royalty interest as an other interest not obligated to bear costs in Section 116. Moreover, Verdad provides no explanation or justification to support its allegations as to the legislature's intent or purpose in Section 116. Specifically, while it is clear that Section 116(7)(a) was meant to allow consenting working interest to recover their upfront drilling costs from non-consenting working interest, Verdad does not provide support to show the interest or show that the intent was to protect, quote, the mineral owner's royalty that is to be paid on the non-consenting working interest lease, as opposed to all non-cost bearing interest. Similarly, Verdad does not provide any support for the argument that the intent or purpose of section 116(7)(a) was to, quote, distinguish between working interests, which are subject to cost recovery and penalty, and mineral interests, again, as opposed to all non-cost bearing interests, or that the use of the phrase royalty or other interest not obligated to pay cost is intended to protect what Verdad says is the mineral owner's royalty and similar interests created from the mineral interest. As stated above, had the legislature meant to protect similar interests created from the mineral interest, it could have just as easily done so. I do want to note that I looked through the legislative history of SB 18230, which amended section 116(7)(a) after the Catamount decision. While I was not able to find a recording in the short time frame to listen to the testimony in the House and Senate committees, there was no indication in the committee summaries or notes that the amendment to the provisions were meant to overturn Catamount, as the Myrick's would have us believe, nor was there an indication that the amendment was confirmation that the provision was intended to exclude overriding royalty interests, as Verdad would have us believe. Thus, we are left to the Commission's statutory interpretation, and as we are not bound by stare decisis, although I do agree that the hearing officer was bound by the Catamount decision, I believe that section 116(7)(a)'s use of or other interests not obligated to pay part of the cost thereof does include overriding royalty interest. Finally, I believe that this outcome is equitable, as it avoids disparate treatment of overriding royalty interest owners based on whether they are carved out from a consenting or a non-consenting working interest, a decision from which the overriding royalty interest has no choice. Unfortunately, this does not end the necessary analysis. The hearing officer indicated in his order, to which the Myrick's filed the exception, that the issue at hand was an alleged failure to make timely overriding royalty interest payments. Relying on Catamount, which I believe he was obligated to do, the hearing officer found that the Myrick's are not entitled to payment on the ORRIs derived from non-consenting working interest prior to the cost recovery period. As I indicated initially, I believe the timing issue at hand was correctly determined. Section 116(7)(a)(1) does not speak to timing, but 7(a)(2) does. A consenting working interest owner is entitled to receive, quote, a proportionate part of the non-consenting owner's share of the production until costs are recovered. And a non-consenting working owner is entitled to its share after the consenting owners have recovered the non-consenting owner's share of the cost of production. While the statute does not address timing of payments for working interest owners, it is silent with respect to overriding interest owners. The only other provision addressing timing of payments is section 118.5, but the provision in 116 concerning non-consenting working interest owners provides an exception to those mandates. I previously noted that there are distinctions between royalty interests and overriding royalty interests. In Greinberg v. Waltman, the Supreme Court stated that an overriding royalty interest is not a freestanding interest. It is carved out of and constitutes a part of the working interest created by an oil and gas lease, and is limited in the duration of the life of the leasehold interest. While the overriding royalty interest owner does not have it to share in the cost of the development, given that the overriding royalty interest is carved out of and part of the working interest, I do believe it is reasonable that the recovery of the timing of the overriding royalty interest is consistent with the timing of the recovery for the corresponding working interest. I did not see anything in the briefing from either party that suggests otherwise. My final point, the Commission is not seeking to involve itself in private contractual disputes. It is undertaking its statutory mandate and adjudicating a statutory dispute. The Commission cannot simply leave this decision to the parties to resolve. Moreover, our decision today will allow the parties to continue to resolve that dispute either amongst themselves or through a judicial review action. In conclusion, I believe that the overriding royalty interests carved out of a non-consenting working interest do not need to share in the cost to repay consenting working interest owners. However, given that the interests are carved out of the working interest, I do believe that the payments are not required to be made to those overriding royalty interest owners during the cost recovery period. And I think legally what that would turn out to be would be not overturning the hearing officer's motion because it does go to timing. However, I do have concerns with what Verdad is proposing to do, and that is carving out part of the overriding royalty interest in order to pay the consenting working interest owner.
Trying to find my unmute button. Thank you, Commissioner Cross, for the extensive deliberative thoughts. I think we appreciate your legal background on this complex topic. Do others desire to weigh in? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Commissioner Cross. I guess I would like some clarification on your interpretation and what you're thinking and making sure that I understand what you're saying, because that was a lot. Okay, so I think what you're saying is the ORI payment will be related to the working interest and whether or not it was a consenting or non-consenting working interest, and the timing of the payment is commensurate with where it derives from, the working interest and whether or not they were consenting or non-consenting.
With respect to timing, yes, because it is carved out of the working interest. And so with respect to timing, admittedly, I didn't see anything in the briefing to suggest one way or another. And I did some research and I don't really see anything one way or another. And the fact that ultimately the decision in Catamount found that the payment does not need to be made during it was called different things at different times, but during the cost recovery period, I think does have a legitimate basis. And so with respect to timing itself, I have no issue with the timing of payments to overriding royalty interests that are derived from non-consenting working interest being paid at the conclusion of the cost recovery period.
Okay, then I feel like there's a part B, and I'm not sure I'm understanding the part B, so I'm wondering if you could give me the elevator speech for that and reiterate what we're saying here.
Sure, and I think to me, the Supreme Court is clear, Colorado law is clear, that overriding royalty interests are not cost bearing. And because they're not cost bearing, it doesn't, without some sort of statutory provision that specifically says it should be cost bearing in this circumstance, it has to be treated as a non-cost bearing interest. The main argument behind why Verdad is saying that the statutory says it is cost bearing in this situation is that the legislature did not specifically use overriding royalty interest in section 116(7)(a), but it did in section 118. However, I think that what you see in 118 is an illustrative example. It says, here are some non-cost bearing interests, such as royalty interests, such as production payments, such as overriding royalty interests. If they only intended to talk about those interests, they could have created an exhaustive list. The fact that it was an illustrative list does not mean that they chose to do so in one, but not the other. Instead, what they say is, hey, just so you know, here are some non-cost bearing interests. So in another section where they say non-cost bearing interest, it doesn't mean that it does not include overriding royalty interest. It just simply means as well as other non-cost bearing interests. So I'm sort of left looking at, because the statute doesn't specifically exclude overriding royalty interests, I think you have to look to what the Supreme Court said, and the Supreme Court on numerous occasions has been very specific in saying overriding royalty interests are non-cost bearing, and even the legislature has agreed in section 118.
Sorry, I just want to make sure I'm understanding. So in what you're proposing, or what you're interpreting, is an OORI does not contribute, is not a cost, isn't a contributing to the costs, but when an OORI gets paid is dependent on whether or not their derived interest is coming from a consenting or a non-consenting working interest.
Cool.
Okay, thank you.
Commissioner Ackerman?
Thank you, Mr. Chair. I certainly recognize and appreciate Commissioner Cross's detailed analysis. I find it very helpful, and I find that based on his significant legal background and industry experience, his opinions on strictly legal matters always hold significant weight in my analysis. I wanted to kind of lay out a truncated, since Commissioner Cross addressed many points, a truncated point of view of where I'm coming from on this issue. And I recognize also that an overriding royalty interest is an undivided interest, giving the holder the right to a proportional share of a larger interest, subject to the lease under which it's created. In my opinion, it should not and cannot bestow broader interest rights upon its holder than the interest right from which it is derived. Or in other words, as stated in common law interpretations applied to recording acts, a grantor can transfer no more than he owns. In the case at hand, an overriding royalty interest derived from a non-consenting working interest, which itself is subject to cost recovery provisions. So even though the ORRI holder did not have a decision in electing a working or a non-working stance in the development, the ORRI is still a derivative of the material interest and should be subject to the rights, privileges, and obligations of the parent interest. In my opinion, the idea that the simple severing of a portion of a right from the whole thereof would ultimately allot to the severed portion more value than the sideboards of the original right as it progresses through due legal and administrative processes is not a reasonable interpretation of property rights in general. And when read in paramateria, the act pretty clearly sets forth that consenting owners are to be reimbursed first during the cost recovery period until the well pays out. Commissioner Cross treated the language that was added in the statute, and I'll reiterate here that the legislature subsequent in 2017 added the language, if and to the extent that royalty is consistent with the lease terms prevailing in the area and is not designed to avoid the recovery of costs provided for in subsection 7B of this section. To me, the extraction of an ORRI from a non-consenting working interest is, whether the intent is there or not, the result of that is to avoid the recovery of costs period. So to me, rather than leaving the point ambiguous, this added language by the legislature strengthens the intent of the statute to not treat ORRI as an end around for non-consenting interest owners to be paid prior to the reimbursement of consenting interest owners. As by principle, a subordinate right cannot be broader than its parent right, this includes an ORRI derived from a non-consenting interest. And I do think the argument is further bolstered because the legislature could have included ORRI in the exclusionary language in the direct aftermath of that decision and chose not to. I'll truncate my thoughts there, but I think including ORRIs derived from a non-consenting interest is contrary to the broader intent of the statute regarding consenting and non-consenting interests, to me, which sets forth that consenting interest holders who bear the cost of development should be reimbursed for that expense until well payout, at which time non-consenting interest owners begin to gain monetary compensation. And I know that's not the point of question here, but rather the ORRIs derived from each of those. Interest holders who bear no costs are not intended in the statute to be on equal footing to working interest holders who bear the costs of development, and they're also not intended to be on equal footing to mineral rights owners. So to me, inclusion of such interest during the cost recovery period, including ORRIs derived from non-consenting interest, undermines the risk-benefit structure of interest holders being able to choose to participate as consenting interest holders or choose to not actively participate as non-consenting interest holders, with the attenuating consequences and stipulations pertaining to that decision, including the extension of those to any rights that are derived from that principal interest. And I would just say that while I recognize that this interpretation may vary in some ways from the interpretation set forth so eloquently by Commissioner Cross, it does arrive at the same conclusion. To me, the ORRI in question in this case should be paid subsequent to the cost recovery period.
Thank you, Commissioner Ackerman. Further deliberative thoughts? Commissioner Cross, do you want to make a motion?
And I'll perhaps look to AAG Davenport here, but I would move for approving the recommended order from the hearing officer with respect to the timing of the payment not having to be made until the end of the cost recovery. I don't know, given that that was the issue at hand, I don't know that we need to go further than that. I think we can probably leave the remaining comments for the parties to discuss themselves. But I think based on that, I think it's appropriate to move for the timing to be paid at the end of the cost recovery period.
AAG Davenport, do you want to weigh in on the motion? We always like our lawyers to help us out here on a lawyerly sort of topic.
Well, thank you, Chair, and thank you, Commissioner Cross. I think by extension, another way to state the motion, if it's acceptable, is to deny the exception that was filed by the MIREX, requesting that the commission reverse the hearing officer's recommended order, given that that's the actual request in front of the commission. I think the appropriate motion is to deny the exception. However, I'd note, one, that if the commissioners do think that even though the ultimate conclusion of the recommended order is appropriate and should not be changed, if the commission either thinks some portion of the recommended order needs to be changed or would like to provide me with the authority to add additional detail into the recommended order when it becomes a final order of the commission, I'm happy to do that as well. But ultimately, I think the motion that was stated was to deny the exception.
I think that's to deny the exception.
Okay. That is the motion that is on the table. Do we have a second?
Second.
We have a motion and a second. At this time, we have an opportunity for discussion on the motion. Seeing no discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Motion carries. All right. Thank you, commissioners, for the consideration of that docket. We have a healthy docket ahead of us. Let's take another, say, 5-10 minutes and get everybody lined up. There's going to be a lot of people lined up to hear this. It's docket 2309-00287. We will start with public comment, followed by Weld County comment, and then the party or the presentation from City and County of Broomfield, followed by Erie, and then presentation by CDPHE, and then presentation by Extraction. So that's a healthy docket. It is 10:30. Let's return at 10:40, and hopefully we'll have most of the folks from the public lined up to be able to testify. All right, welcome back, everybody. This is the Colorado Energy and Carbon Management Commission January 24th hearing. We will now take up docket 2309-00287. This is a request for approval of certain pending Form 2s by Extraction Resources. To begin, we are going to take up public comment first. And I see that we have Mr. Schiller,
yes,
who is someone that has signed up for public comment. You're recognized for 3 minutes of public comment.
Okay. Well, hello, Commission. My name is Lee Schiller, and I'm speaking on behalf of all the affected persons in Broomfield, and that's in Broomfield City and County, along with 93 other residences. I'm an affected person, which is defined as a person residing within 2,000 feet of the proposed hydraulic fracking site at the Coyote Trails pad, which is in unincorporated Well County. In fact, there are approximately 18 residences that are within 1,500 feet in Broomfield, and I reside at one of them. Now, there have been extensive medical studies detailing the residual effects that occur to people residing within 1 mile of a hydraulic fracking site. Cancers increase eightfold. I'm a 2-time cancer survivor myself, and asthma, respiratory issues, birth defects, and gastrointestinal symptoms all skyrocket. The 2,000 feet radius in Broomfield contains many families with a lot of small children, along with expectant mothers, based on the 68 comments that we did receive on this case. Children tend to be more vulnerable to the effects of fracking. Unfortunately, medical issues become more acute and frequent as proximity decreases. This is due to increased air pollution, and contaminated groundwater and soil based on the chemicals, which are benzene and toluene, which are used in the hydraulic fracking process. In addition, you factor in the noise and the ongoing illumination required for 24-hour continuous extraction for an estimated 10 months. Extraction estimated that they'll begin this in October 2024. It'll be completed in August 2025, which will create extreme stress and anxiety for us affected persons. Coincidentally, Civitas Extraction has provided a 32-foot sound barrier wall for the proposal, but it's only for the areas that are south and west of the Coyote Trails pad, and we live east of it, unfortunately. Civitas Extraction is basing the proposal on the 2017 COGC approval of 45 wells at Coyote Trails, of which 27 were completed and operational beginning in February 2018 through the end of 2019. In 2018, the total number of residences in Broomfield within 2,000 feet at Coyote Trails was 0. We didn't exist. Palisades was not built at that time. Nonetheless, COGC received 101 complaints from residences regarding the noise and odor coming from Coyote Trails from 2018 to 2019. The August 2nd, 2017 permit expired on November the 19th, 2020, as a condition of approval from the COGC. Therefore, Civitas Extraction has to submit a new application for permit under 2024 criteria for each of the 18 wells. If it intends to resume hydraulic fracturing at the Coyote Trails pad, that is. They haven't done so. They've limited their offer based on 2017. Finally, the lack of notification by Civitas Extraction to us affected people in Broomfield is extremely insidious. It denotes an utter lack of transparency regarding their intentions. Civitas provided their plans to ECMC to resume operations at Coyote Trails pad through AFPs for 7 new wells back on January the 12th, 2023. No notification was provided to any municipality, even though we as affected persons resided within 2,000 feet of these drilling areas. Despite these wells being located in unincorporated Well County, this is a violation of SB 19181, Rule 604B, which is dated April 6, 2021, which states the following. No working pad service will be located more than 500 feet and less than 2,000 feet from one or more residential building units or high occupancy building units unless one of the following conditions is actually satisfied. The residential building units and tenants and high occupancy building unit owners and tenants within 2,000 feet of the working pad surface explicitly agree with informed consent to the proposed oil and gas location. Coincidentally, we, the affected people, were first notified of Civitas Extraction plans on Coyote Trails on January the 12th, 2024 by our Broomfield council persons, Laura Anderson and Jean Lim. That was 1 year after Civitas provided their AFPs to the ECMC. The developer of the Broomfield residential units, who is Lennar, never disclosed the information to us within our agreements of sales, nor did they provide information regarding the previous hydraulic fracking completed on Coyote Trails back in 2018 and 2019. Therefore, we were provided only 10 days to prepare and assemble a public opinion response to this hearing, which to me is an obvious lack of community outreach by Civitas. In conclusion, we, the affected people of Broomfield City and County, are requesting that ECMC deny Civitas the right to resume drilling and hydraulic fracturing on the Coyote Trails pad based on the violation of SB 19181. To approve Civitas's AFPs for the site would set a dangerous precedent for similar cases throughout Colorado and undermine the commission's role in protecting public health, safety, welfare, and the environment. We, as the affected people of Broomfield and as Coloradans, must have our faith in government to look after the interests of all. And I'm asking you to reject the proposal from Civitas Extraction. Now, there are 225 residences within 2,000.
Mr. Schiller, if you could wrap up, you're well beyond the 3 minutes.
Oh, I'm done.
Okay, thank you so much. We really appreciate you being with us. Just trying to give everybody a fair shot at being able to testify.
I understand.
All right, we now will hear from Emily Bear.
Good morning, commissioners. My name is Emily Bear. I'm a council member in the town of Erie, but I'm also an impacted resident, force pooled by Coyote Trail site. And it's in that capacity that I'm speaking to you today. After my son fell gravely ill from exposure illness from a well site near our home, we were approached and asked to lease our minerals for Coyote Trails. In an effort to insulate and protect our family, and importantly our son, we said no. They said, that's okay, we'll take them anyway. And they did, and they have, and we have received no compensation whatsoever for our property that's been taken. But we did receive all of the legal documents when Extraction went through bankruptcy a couple of years ago. If these permits and the additional 11 disappointingly encouraged by Director Murphy's letter and attached to this docket are pushed through a loophole left in the mission change rulemaking, or because we have inadequate consideration or a missing metric for cumulative impacts, table it. Table these permits. Do not approve them. Something is broken and we have work to do. When Commissioners Cross and McGowan came to Erie for the cumulative impacts listening session in December, we discussed the legal lawful considerations versus moral ethical ones. This scenario, these additional wells at this site, surrounded by hundreds of homes and families within the setback, multiple schools and parks, and a mile away, the Children's Hospital, where we took our son so many times when he was so sick. This scenario begs the moral ethical question, should these wells be approved? And the answer is obviously no. And illegally, should these wells be approved in a post-181 world? The answer is also no. The legal and ethical considerations have come so nicely into alignment on this. There are many reasons why these permits should be denied, including inadequate BMPs. The original site was approved for 2 phases and they have completed 2 phases. And now they just want to tack on more phases. New drilling should be held to our current standards. You have the authority to deny these permits. You have the ability to deny them. And you have the mandate from the voters of the state of Colorado to protect public health, safety, welfare, and the environment. And you have the moral directive to deny them. We, the impacted public, are counting on you, the commission, to do what is legal and to do what is right and deny these permits. Thank you.
Thank you very much, Ms. Bear, for testifying to us this morning. We do appreciate it. We now will hear from Christian von Woutenberg.
Good morning, commissioners. I come to you as a battle-weary activist, a former trustee for the town of Erie, a directly impacted resident, and a father of 2 amazing teenage girls. I've been an Erie resident for 17 years. I live 800 feet from the 6-well Pratt pad, 3,400 feet from the 7-well Waste Connections pad, 4,000 feet from the 27-well Coyote Trails pad, and 1.5 miles from the proposed 26-well Draco pad at the Crestone Hub, which includes the 11 wells at the Windsock pad. Every single one of these wells was drilled after I moved into what I thought was my dream home. Like many of the other residents that provided comment for today's docket, I was scared, angry, and terrified. We have 137 active wells and 238 plugged-in abandoned wells within our municipal boundaries. I could go on, but I'm tired of telling you how fracked we are in Erie. We are the cautionary tale for other neighborhoods, one told about a heavy industry operating indiscriminately and with wanton disregard for health and safety in residential neighborhoods. If you don't remember the drilling at Pratt and Waste Connections, have a look at your complaint records. They logged the most complaints for any frac operation in Colorado ever, over 900 complaints together. They are the number 1 and 2 for total complaints logged respectively. Coyote Trails is number 6 on the list with 123 complaints logged during the drilling, fracturing, and completions operations performed in 2018 and 19. I could go on, but residents are either confused or tired of navigating the complex web of antiquated tools for submitting complaints about air quality, noise, odor, nosebleeds, and headaches to the CDPHE, the ECMC, the PUC, the local government, the county government, and the operator involved. It's a perplexing, demoralizing, and complex process and leaves residents feeling helpless against the oil and gas extraction industry. But there's hope. You, the commissioners, can deny these Form 2 permits by extraction based on a simple procedural violation. The Form 2A issued for the Coyote Trails pad expired on November 19th, 2020. They had their chance to submit additional Form 2s for 3 years, and they did. They used it to drill 27 wells under pre-SB 181 regulations. If the operator wants to drill additional wells at this location, they must submit a new Form 2A. That's the law. And that's how this process is supposed to work. A Form 2A doesn't give an operator a license to drill in perpetuity for this exact reason. Technology changes. Our understanding of the health, safety, and environmental impacts of hydraulic fracturing changes. You must evaluate a new Form 2A for Coyote Trails with this current understanding against the current regulations. Then you'll see how there's hundreds of homes within 2,000 feet of this pad, how the region is already overburdened with the cumulative impacts of an oil and gas extraction, and how this heavy industry does not belong in our neighborhoods. And then you can properly deny the permit to drill additional wells at Coyote Trails. Thank you.
Thank you very much for your testimony this morning to us on this docket. We do very much appreciate your participation. Hearings Manager Thomas, we had a couple of other people that had signed up. Are you able to locate them within the panel?
Yes, we had a couple late signups, Jen Phelps and Representative Jennifer Parenti. Both of them don't appear to be able to make it, so I've told them to file written comments. I'll get those to the commissioners in the portfolio as well. And I believe Representative Parenti already forwarded her comments to you. So at this time, we can move to Jennifer Teeters from Weld County.
Yeah, I would note for the record that we received upwards of 40 some odd written comments, including the comments from Representative Parenti, and we've all reviewed all of those comments at this point. All right, so with that, we will hold public comment for the time being. If either of the other remaining folks show up, we'll get back to them. And now we will move to comments from Weld County. Ms. Teeters.
Hi, good morning, commissioners. Thank you for the opportunity to speak for a couple minutes about the Weld County WOGLA process regarding the extraction oil and gas, Coyote Trails oil and gas location. In 2017, Weld County's Department of Planning reviewed the Coyote Trails application and approved the permit under WOGLA 17-0074. Extraction hosted an open house at the Erie Community Center on August 24th of 2017. Notification of this meeting was sent to residents within a half-mile of the pad. Extraction submitted their WOGLA application to the Planning Department on September 14th of 2017. Weld County did not receive any public comments on this application. The application was deemed complete and compliant with Weld County code requirements at the time of the submittal. Weld County Department of Planning Services approved this permit on October 3rd of 2017. Most importantly, other than the dates and brief information I just mentioned, Weld County has spoken with Civitas and they have agreed to update the BMPs for this permit. We feel this is extremely valuable information because even though the permit was already approved and they are allowed to drill the remaining wells without getting a new WOGLA, it shows their willingness to implement additional standards on an existing permit to further protect the health, safety, and welfare of residents and the environment. Weld County supports approval of these Form 2s, and that is all I have for today. I will remain active on this Zoom call for the duration of the docket if any further questions are had.
Thank you very much, Ms. Teeters. We do appreciate the relevant local government's participation with us. Does any commissioner have questions? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Ms. Teeters. You may not know this, but do you know during the original WOGLA review process, how many occupations were contemplated as part of this application?
I do not have that information, and I don't have that information. I could look up if they had alternatives, but at the time, I don't believe we had that.
Okay, thank you.
Are there questions for Ms. Teeters? All right, thank you very much, and thanks for sticking around. We've got a lot of people to hear from on this docket, and with that, we're going to move to a presentation by the City and County of Broomfield. And I would just, before we go to Broomfield, let me sort of set the stage. I probably should have done this at the beginning. This is not a typical request to the commission. These are for Form 2s, which are wells. The 2A was approved in 2017. That's the location. And the City and County of Broomfield, as well as the town of Erie, had requested that this be elevated to the commission from a director administrative review. And the commission a while back agreed that that was the right course of action. And so we are hearing whether to approve, not approve, or conditionally approve the Form 2s at the commission level. That is something that we are allowed to do by our rules and regulations. We also noted another while back, I forgot when, that there was a request for the City and County of Broomfield, as well as the town of Erie, to be elevated to party status. And there was an objection to that from Extraction Resources. We heard oral argument on that and made the decision a while back, again, I don't have the specific dates, that neither the City and County of Broomfield nor the town of Erie met the legal requirements for, quote, party status. But I also suggested at that time, and upon that notice, that the City and County of Broomfield and the town of Erie would be given adequate time to be able to sort of present their position. And so that's kind of where we're at right now. Is we're going to hear from the City and County of Broomfield and then the town of Erie, and we're going to hear their positions. So even though they're not designated party status in quotes, we do desire to hear their position relevant to the consideration of these Form 2s. So having set the stage, we now will hear from the City and County of Broomfield.
Thank you, Chair Robbins. Let me share my screen. Can everyone see that?
Yes, we can.
Pat Gilbert, Deputy City and County Attorney for Broomfield, and Broomfield really appreciates this opportunity to present at today's hearing, and we will present in 3 parts. First, I will discuss the legal landscape and approval history. Then Danae Brouillard, our Director of Strategic Initiatives, will discuss the residential development near the pad and Broomfield's oil and gas experience. Jason Volling, our Director of Public Health, will discuss the current knowledge about toxic air emissions and adverse health impacts on residents living near oil and gas operations. This commission faces a critical decision about whether to approve these oil and gas operations, given the significant number of homes, schools, childcare facilities, parks, and even a children's hospital nearby and downwind from the Coyote Trails pad. During the 6 years since the location was first approved, we've learned a lot more about toxic air emissions and adverse human health impacts of these oil and gas operations. This knowledge is based both on experience and peer-reviewed scientific studies. There is now a new protective standard governing oil and gas operations. The operator must demonstrate, and the commission must find, that these oil and gas operations protect and minimize adverse impacts to public health, safety, welfare, and the environment. Broomfield respectfully requests that the commission defer to CDPHE's assessment that even with BMPs, the proposed Coyote Trails wells have the potential to affect the public health of a significant number of residents, especially children and the elderly. Back in 2017, when Extraction submitted the Form 2A for approval, Extraction represented that the entire development would be completed in 2018. And Extraction never disclosed to the COGCC, to the community, or to local governments that it would come back 8 years later or 6 years later to drill 18 more wells. If Extraction had completed the wells back in February of 2018, we wouldn't be here today. But here we are, and the legal standard for approval has changed significantly. The Form 2A filed by Extraction did not seek an open-ended right to drill up to 45 wells at any time in the future. And there's nothing in the rules, either now or previously, that states that the Commission's approval of a Form 2A grants the operator a right to a certain number of well slots that can be drilled at any time in the future, even after the expiration date on the Form 2A, which is in 2020. The oil and gas development represented in the Form 2A is not the same development that is proposed today. If you compare the wellbore plan that's contained in the Form 2A with the information in these Form 2s, you will note that the wellbores have changed significantly. The phasing has changed. The Form 2A lacks the BMPs needed to comply with current rules, and there is no end date for completion of 45 wells. Broomfield is also very concerned about the non-transparent way Extraction sought approval for these operations without notifying the proximate local governments, without notifying the nearby residents, and without filing an amended Form A or any document that lists for the agency and for the public all of the BMPs that Extraction has now committed to providing and that are needed to comply with CEMC's new rules. At a minimum, based on substantial changes to these operations, Extraction should file a revised Form A as required by Rule 304A3. Broomfield is also requesting that Extraction be required to provide 60-day notice to residents within 2,000 feet prior to drilling to give those residences an ample opportunity to relocate in order to avoid exposure to toxic air emissions. I'll now turn it over to Danae Brouillard to talk about the surrounding community.
Slide, please. Before I dive into Broomfield's experience related to adverse impacts from unconventional oil and gas development, I wanted to show how the area has changed in the past 7 to 8 years since the original 2As were approved in 2017. As you can see from the 2017 photo on the left, the city and county of Broomfield portion of the map, which is noted as the land within the dotted area, was vacant land. If you look at the map on the right side of your screen from 2023, you will see that there is now an entire neighborhood full of inhabited homes. The Palisade Park neighborhood includes approximately 90 RBUs within 2,000 feet of the Coyote Trails pad, with the closest RBU being about 1,300 feet away. It is also our understanding that the access to the pad, as well as the haul road that will be used to remove drill cuttings from the pad, is located off of County Road 7. As you can see from the images on the screen, this is even closer to these Broomfield residents, with the road being about 450 feet from the western side of the Palisade Park neighborhood. The access road is also about 450 feet away from a public park, which I'll show on the next slide. In addition to the safety concerns from the increase in traffic, residents will also experience an increase in toxic air. This increase will not only come from the pad operations and uptick in traffic, but also from the trucks hauling the drill cuttings from the pad to the Front Range landfill. Next slide. I wanted to now share an image of what currently exists within 2 miles of the Coyote Trails pad. The image on the screen provides a 1 mile radius from the Coyote Trail pad site noted in orange and a 2 mile radius noted in purple. Within the 1 mile radius, there are 4 schools or child care facilities, 1 assisted living center, and more than 10 parks and outdoor meeting spaces. Additionally, the Children's Hospital on Highway 7 is just slightly over 1 mile from the pad. Consideration of these gathering spaces, in addition to the neighborhood that I spoke about earlier, adjacent to the pad, is critical The magnitude of impact, if approved, extends beyond the neighborhood. Additionally, NOAA data indicates that prevailing winds in the area are westerly, which exacerbates the impact to the community. Director Veiling will speak more specifically regarding the adverse impacts within the distance later in the presentation. Next slide. Next, we wanted to highlight the cumulative impacts on our residents, as the adverse impacts on the residents are compounded due to several other producing wells and the landfill near the Coyote Trails pad. The image shows existing and proposed pads for more than one well within 2 miles of the neighborhood, as well as all existing producing pads in Broomfield. The blue circle shows a 2-mile radius from the Palisade Park neighborhood. Like the proposed Coyote Trails pad, these wells can also emit hazardous air pollutants, as technology has not yet advanced to the point where oil and gas wells are zero-emitting facilities, therefore compounding the adverse impacts on public health and environment. Next slide. In 2017, Broomfield entered an operator agreement with Extraction for the development of 6 unconventional pad sites in Broomfield, which were displayed on the previous map. One of the pads, the Livingston pad, was approximately 1,400 feet from the nearest Broomfield residence, and 18 wells were drilled. It is a near same scenario that the Commission is considering today. Extraction employed BMPs and built and drilled a pad considered to be industry leading, including a tankless facility and use of non-emitting pneumatic controllers. We learned from the Livingston pad that even with BMPs and industry-leading standards, residents were adversely impacted by noise and toxic air emissions. Broomfield implemented a complaint system in October 2019 to track, analyze, and respond to resident concerns regarding potential adverse impacts associated with the extraction well sites. Since its inception in 2019, Broomfield has received over 1,800 complaints, and over 650 were health-related. Broomfield also worked in partnership with CDPHE, who received additional complaints. Of the 265 complaints received by CDPHE from October 2018 to May 2020, 88% were related to health and 80% were reported during pre-production activities at Livingston. The quantity of complaints is demonstrated on the map. As you can see, it is difficult to see the Livingston pad, which is on the southern western side of the map that you're looking at. And that's because of the number of complaints received specifically for pre-production and at the Livingston pad. As stated earlier, there were 18 wells drilled. The nearest resident was about 1,400 feet from the pad, and is what is similar to what we are talking about today. Next slide. In 2019, Broomfield, in conjunction with Colorado State University and Ajax Analytics, stood up a state-of-the-art air monitoring network to collect data and monitor VOCs, as well as additional criteria air pollutants. As you can see from the diagram, the network was structured to collect extensive data related to all 6 pad operations, and CDPHE was consulted in the program development. Next slide. Weekly air canister data indicates VOCs and oil and gas tracer compound concentrations increased during pre-production activities. The bottom 2 graphs illustrate significant increases in ethane as well as benzene, a known carcinogen, throughout pre-production. Program data also indicates the vast majority of whole air canister samples, triggered as a response to a TVOC threshold exceedance, occurred during the drilling phase, specifically 86.5% based on normalized data. I will now pass it to Broomfield's Public Health Director, Jason Veiling.
Thank you, Danae. As a local public health agency, we were thrust into monitoring the impacts of unconventional oil and gas development on our residents' health. Today, I'm going to discuss what we learned from the literature and from our own health and air studies that demonstrate there are adverse public health impacts of living near unconventional oil and gas sites. At the time of the approval of the Coyote Trails Form 2A, research on the public health impacts from unconventional oil and gas development was still evolving. In early 2017, CDPHE's assessment of the potential public health effects found that based on the available air monitoring data, the risk of harmful health effects was low, but there was a need for more detailed exposure monitoring and analysis of health effects living near oil and gas operations. Given the monitoring the health effects of oil and gas is not traditionally a local public health role, we brought in the leading public health researchers working in unconventional oil and gas development, including Dr. McKenzie, Dr. Alshouse, and Dr. Collette, to document our findings, inform regulators, and contribute to the scientific evidence. In 2018, as we were setting up our monitoring systems and beginning to collect data, new research emerged from Dr. McKenzie that found there is an increased risk for cancer and non-cancer health effects at distances closer to 500 feet, and that our current regulatory policies may not be protective of public health. The following year, CDPHE released their human health risk assessment, and you all know that study found that exposures to chemicals used in oil and gas development may cause short-term negative health impacts during worst-case conditions, and there is a possibility of negative health impacts at distances from 300 to 2,000 feet. Both of these studies contradicted CDPHE's original finding in the 2017 report. Additionally, the studies demonstrated a need for additional monitoring of health symptoms at the local level. As a result, we set up a local oil and gas health concern program with the support and collaboration of CDPHE. Self-reported health concerns were collected and correlated with our air monitoring and pad operation data. However, it became clear that we needed a more robust peer-reviewed study to understand the impacts of living near unconventional oil and gas development. Next slide. In 2021, we partnered with Dr. McKenzie at the Colorado School of Public Health. We collected health data from 427 randomly identified Broomfield residents to better understand self-reported health symptoms associated with living in close proximity to unconventional oil and gas development. And I know you've seen this slide, but I want to reiterate what we found is adult respondents living within 1 mile of unconventional oil and gas site in Broomfield reported significantly greater frequencies of upper respiratory and acute symptoms than those living more than 2 miles away. We also found respondents living within 2 miles of unconventional oil and gas site also reported that their children experienced significantly greater frequencies of lower respiratory, gastrointestinal, and acute symptoms. Our study was released in May of 2022 and published in February 2023 in the International Journal of Research and Public Health. It was the first study published on the associations between self-reported health symptoms and unconventional oil and gas sites that had well-defined BMPs. Next slide. Additionally, Broomfield also set up an extensive air monitoring system in partnership with CSU, Ajax, and Boulder Air. Dr. Collette with Colorado State University analyzed our monitoring data and published his findings in the Journal of Atmospheric Environment. Key findings include that oil and gas operations with BMPs still emit concentrated VOCs, that there was an increased concentrations of many VOCs near well pads during pre-production activities, and that while all the weekly average benzene mixing ratios remained below the chronic health guideline values, plumes using PID trigger canister contained benzene levels reaching as high as several hundred parts per billion. Next slide. Given all this data and evidence, my conclusion is even with best management practices, there are adverse public health impacts to residents. This is substantiated with what we've discussed before, over 1,800 air pollution, noise, and odor concerns. Our air monitoring data found that regardless of strict BMPs, there are still increases in the frequency, magnitude, and duration of VOC emissions. Our own study with CU that found residents living near unconventional oil and gas sites reported health symptoms than those living, that residents living near the unconventional oil and gas sites reported more health symptoms than residents not living near those sites. And this was aligned with previously published epidemiological studies and the body of scientific literature that indicates unconventional oil and gas development affects the health of nearby residents. Given this, I concur with CDPHE and their findings that the Coyote Trail site has a potential to affect public health of a significant number of residents, especially children and the elderly at both home, schools, and outdoor gathering space. And additionally, that there will be adverse public health impacts. Thank you.
All right. Thank you to the panel for the presentation. We do appreciate it. At this time, the panel is open for questions from commissioners. And we'll get to you, Mr. Frank, here in just a sec. Commissioner Messner?
Thank you, Mr. Chair. Thank you to City and County of Broomfield for the presentation and the information that was provided. I want to get a little more information on the changes to the surrounding land uses between I think your slide was between 2017 and today, 2023. So I think I heard, at least in my notes, that approximately 90 new homes were built inside of the Palisade subdivision. Between the initial occupation of this particular well pad and what's there currently inside 2,000 feet of the particular location. Is that, am I right there?
That is correct.
Okay. And talk to me a little bit about other changes to the surrounding land uses or around the pad in particular inside 2,000 feet besides those RBUs. Is there any other changes that you wanted to highlight as far as surrounding land uses or road patterns or traffic patterns or anything like that?
Danae, did you want to speak to that?
No, thank you for the question. I think that accurately just seeing the change from 2017 to 2020 or to 2023, vacant land now platted for residential, 90 RBUs within that 2,000 foot perimeter that you mentioned, with obviously a lot more RBUs as well, just on that outside of the 2,000 foot perimeter. And the only other thing I would mention is that traffic pattern will change with increased traffic into the pad, with the access point being on that County Road 7, which you can see runs right in the middle of the residence and that park. And then on the east side or the west side of County Road 7 being the access. So there will be traffic pattern changes as well due to the increase in residents and then the pad operations itself.
Thank you. That's helpful. That's the only question I had right now.
Can I ask a follow-up question along the same lines? When were the 90 Palisade residential dwelling units approved? And do you know whether City Council, in making said approval, was cognizant of the fact that this well pad was nearby, that it had other wells that were going to be drilled, or that they thought that the wells were not going to be drilled and that was over because of the extinction of the pad 2A in, I think, 2020 after 3 years? I'm just kind of open-ended question. Was there consideration from City Council relevant to these sorts of concerns?
I'm afraid I don't have the exact answer to that. Typically, there is a fairly robust process around the land use approval, and it goes through our Land Use Review Commission as well as our council, and the entire area is taken into effect, but I don't know for certain whether those specific details were considered by council in the final determination back in 2019.
Okay, fair enough. Other questions for the panel? Commissioner McGowan?
Thank you, Mr. Chair, and thank you to everyone who's testifying today and sharing your information. I'm wondering, I didn't see slide numbers, so I'm not going to be able to tell you the slide numbers, but I think there's one about toxic emissions and the canister data that you all collected, which I think, Ms. Briard, you may have said that the readings are within the health risk levels except for some plumes during pre-production. Am I understanding that right? Sorry.
Danae or Jason?
Sorry, Commissioner McGowan. I was jumping back and forth between the screens. I'll let Director Veiling speak to that a little bit more, but Pat, can we display that slide again? It's the air quality, what the data showed slide. And then Director Veiling, if you don't mind expanding on Commissioner McGowan's question.
Sure. Thanks for the question, Commissioner McGowan. Yes, when you look at the data, what we saw is when we did often see spikes in VOCs, which again, I said there were numerous spikes that happened. Oftentimes they were below those health guideline values. But we did have instances within plumes, and that was one of the effective strategies that were employed by Dr. Collette for our comprehensive air monitoring system to be able to track and determine specific concentrations within those plumes. And that's where we saw some of these spikes that were extremely concerning, especially those ones that were significantly higher than the health guideline values.
Thank you. And did you all track the distance the plumes traveled?
We did. That's, I don't have the specific information in front of me, but that is something that Dr. Collette tracked along with our other two vendors that established our air monitoring system. And so looking again at what was happening near site to the pad, what was happening as it traveled further away, and then what was happening as it was traveling into our impacted neighborhoods.
So did it travel more than 2,000 feet?
We found some instances where it did.
Thank you.
Other questions for the panel? Commissioner Cross?
Thank you, Mr. Chair. And I want to follow up on a little bit of what Commissioner McGowan was just asking about. When you talked about the spikes, were those spikes measured over a short period of time? Were they done the same way as the EPA looks at the spikes, or can you provide a little more detail on that?
Yeah, so, and I believe this has been shared before, is when we looked at the spikes, we were really looking at those 1 minute intervals and then comparing that to health guideline values to establish what those spikes were. It is something that we know that the literature is evolving to more of looking at the spikes in that way, but it's not something that CDPHE or the EPA uses as a validated methodology at this point in time.
Thank you. And I'll admit, part of my questioning was also addressed by Chair Robbins, but I just want to make sure I understand the timeline. So extraction, now Civitas, but extraction did work with the city and county of Broomfield back in 2017 to identify location for the drilling as well as BMPs that would be used on the drilling. Is that correct?
I'll let Pat.
Yeah, I don't know the extent of those conversations, whether it got into best management practices, but this was all at the same time that extraction was seeking to develop what is now the 6 pads in the Broomfield development. So there were conversations that overlapped between the Coyote Trails pad and the pads in Broomfield, and some of the wells that were originally slated to be drilled from Broomfield were moved to the Coyote Trails pad. I hope that answers your question.
I think so, but there were discussions that occurred, and I believe it's 2017. Sorry if I'm wrong on those dates, but there were discussions that occurred with the city and county of Broomfield with respect to at least as you said, at least with respect to the location of some of these. Is that correct?
That is correct. We were aware generally of the Coyote Trails location.
And just to confirm with what Chair Robbins was asking about later, there was approvals later on of some of the different housing developments that are now within the 2,000 feet of the Coyote Trails path, correct?
Correct. And that those approvals would have happened past the date that we thought the operations would be completed in 2018. Okay.
And then my final question is, and it'll be a two-part, but does the city and county of Broomfield have a reverse step back in its ordinances? And if so, what is that?
That's a great question. We do have a reverse setback, and I believe it's 2,000 feet. I am not 100% certain. Our reverse setbacks were enacted in increments after Senate Bill 181.
Do you know if there was a reverse setback prior to 181?
I don't believe there was. I don't believe we could have. I don't think that was within our authority pre Senate Bill 181.
Thank you.
Commissioner McGowan.
Thank you, Mr. Chair. Ms. Gilbert, I'm wondering if you can review for us again the language in the Form 2A that led the county to believe that operations would be done by 2018.
Thank you for the question. There's a few pieces of information in the Form 2A. There is on page 2 of the Form 2A, the estimated date of interim reclamation was 2/21. I believe that was changed to a little bit later, but in that same time frame of 2018. And an interim reclamation would have been for all 45 wells based on the representation that was on, I believe, page 8, that says this pad will be constructed to allow for the drilling to occur in phases consisting of an appraisal phase of 7 wells and the full development phase consisting of the remaining wells. So that indicated all 45 wells would be drilled prior to the estimated reclamation date in 2018. And then also on the top of the Form A in bold is the expiration date of 11/19/2020. And then the language in the conditions of approval where the director signed indicated that all representations, stipulations, and conditions of approval stated in this Form 2A for this location constitutes the representations, stipulations, and conditions for approval for any and all subsequent operations on this location unless this Form 2A is modified by a sundry notice or amended Form 2A.
Thank you.
Further questions for the panel?
Chair Robbins, may I just add one follow-up to Commissioner Messner's question? I did want to just briefly mention the change. The 28 units on the western side of the development are also our affordable housing units. And I should have pointed that out earlier. So those units are on that side closest towards the pad site. And I did want to mention that for the commission's consideration as well.
Is that part of the Palisade subdivision?
Correct.
And that was, I think, some 90 total additional units, 28 of which that are the closest to the pad are affordable housing.
That is correct.
Okay, thank you
And
for
Chair
that
Robbins,
clarification.
if I
Go
can
ahead.
add to your, I believe I was incorrect in some of the information I provided. The preliminary plat and PUD was in May of 2017, and it does not appear to have mention of oil and gas.
Okay. Great, thanks for that follow-up. Commissioner Messner?
I just wanted to make sure that I understood that. So the zoning platting associated with the Palisade subdivision was done prior to the permitting on this oil and gas location. Is that my understanding?
I believe, yes, the preliminary plat was done in 2017. And then of course, later you have the actual, when the development comes in and you have all the details of the development, that was later.
Okay.
But the preliminary plat was 2017.
Right. Thanks.
All right, any final questions for the panel? All right, seeing none, we thank you very much. I assume you will be sticking around for the remainder of the hearing, and if we have further follow-up questions, we have the right to recall you for those questions. But thank you very much for your presentation. I hope that the allowance of the additional time for the presentation allowed the City and County of Broomfield to adequately state its case, even though you were not allowed in as a party. So with that, we're going to move to the next commenter, and that is going to be the comment and presentation by the town of Erie. Mr. Frank, I see you are with us. Is there anybody else, or are you holding down the fort on your own here?
I'll be holding down on my own, though I do have counsel available to address questions that are above my pay grade, as it were. But I'll be your lone presenter for the interest of the town of Erie today.
I think we always appreciate folks from the town participating with us, and I'm sure you'll do fine. So with that, if you want to share your screen.
Sure. I assume you can see this?
Not quite yet. It's kind of in a
my screen
holding
is
pattern.
loading. Apologize for the technical difficulties here.
Yeah, maybe.
Let me try that one more time.
Okay.
All right. Is that any better?
Yep, that is better.
Okay, very good. Good morning, esteemed commissioners. I am David Frank, the Director of Environmental Services for the town of Erie, and I'll be providing the testimony on behalf of the town in consideration of the Coyote Trails applications for permit to drill. I think Broomfield did a fantastic job of going over the impacts that have been documented, the impacts that will be expected by our residents. And so in the interest of time and to not be duplicative, I'm not going to be covering that, but I do understand CDPH&E will also be covering some of that issue. What I do intend to talk to you about is communication and community outreach provided to date by the operator, the rules as applied to this situation and their relevance, the requirements and consideration which are necessary in the post SB 181 world for the approval of oil and gas operations, a brief summary of our position, what we would request that this commission consider, a justification for those positions, why we think it is necessary and relevant. Finally, a brief overview of the implications of the decision before you, and then a very short conclusion. So without further ado, the question must be asked, does honesty and communication matter? This is from the WOGLA permit. Granted back in 2017, it contemplates 2 occupations, an appraisal phase in 2017, followed by the production phase, or excuse me, the development phase of the remaining wells in 2018 and 2019. This is also from the WOGLA permit. This is their transportation plan. You can see the duration of the first occupation, the appraisal phase. And here you have the second phase, which I think it's critical to note that this development phase is for up to 38 wells. They did not say that they would drill 45 wells absolutely, but that they would occupy 2 phases, an appraisal phase and then a development phase, presumably based on that appraisal phase, for up to 38 wells, whatever they thought appropriate. This is from the Form 2A, again, saying that there would be an appraisal phase and a full development phase consisting of the remaining wells, whatever wells they thought appropriate at that time. This is one of the conditions of approval on that now expired Form 2A location assessment. Saying that there will be an appraisal phase and then a full development phase. And as a condition of approval, during the full development phase, sound walls would remain in place throughout the duration of the 2 phases. Since those sound walls have been taken down for 5 years now, I think it was a safe assumption on the part of Broomfield as well as Erie and our residents to conclude that the conditions offered in the original permit were fulfilled. 2 occupations took place, up to 45 wells were drilled, and the conditions of these permits are satisfied. The last communication provided to our residents was on August 24th, 2017. That was 2,344 days ago. No efforts to communicate with our residents or even with us as local governments have been attempted since. And in that, the specifics of the proposed Coyote pad were discussed, including phasing of the pad and schedule. Those communications provided to local governments as well as residents did not say, we're going to drill in 2017, we'll come back in 2018, maybe in 2019, and then maybe, I don't know, 6 years later, 20 years later, whatever we really feel like, we're going to come back and drill again. No, it was communicated very clearly that this pad would be occupied through 2019 and no later. Those are the assumptions of home buyers. Those are the assumptions of families, and those are the assumptions of this local government, because that's what was provided to us. Now, of course, they absolutely could have communicated in 2019 or early 2020, You know what? We're contemplating a third phase, just so you know. Some of you may want to sell your homes. Some of you may not want to buy these homes. Maybe the local governments would like to implement land use restrictions with the knowledge that there will be further drilling and fracking at this location. For 6 years, nothing of the sort was communicated. They could have reached out in January 2023, 1 year ago, when they filed these applications for permit to drill and said, hey, heads up, Mr. Frank, just so you know, just so your residents know, we're entertaining a third occupation. That didn't happen either. I found these Form 2s of my own research, of my own volition, and then reached out to ECMC staff to say, hey, is this a joke? Unfortunately, it's not a joke, and nobody's laughing. What are the applicable rules here? What are we dealing with? Of course, this is the general requirement for approval of all oil and gas operations, that you will approve operations only if they protect and minimize adverse impacts. And of course, denial of approval does not constitute waste. The burden of proof falls solely upon the operator to make this demonstration. That has not been done to date, as the service impacts were not assessed against the current rules and the new protective standards offered by SB 181. In fact, this Form 2A was approved under the mandate at the time to foster the development of oil and gas resources. And that's what it did. The Form 2A, as it stands, does not meet the new protective standards, as it was not designed to do so. It is the mandate of this commission, as brought to you by Colorado voters via SB 19-181, to act in a manner that is protective of public health, safety, welfare, the environment, and wildlife resources. This is codified into Colorado Revised Statute 3460-106, declaring that the authority granted to you that you shall regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts to public health, safety, and welfare. Of course, we also have to talk about Rule 308, which dictates the approval procedure for Form 2. And I just want to note that you have the ability to request, and the operator has the obligation to provide any relevant and necessary information in order to determine that these actions are in fact protective. You have the authority to ask for information. I also, of course, have to highlight the setback provision. I'm not going to read your own rules to you anymore. For the interest of time, we're going to move on. But fear not. There is already a solution within your rules, a very well thought out and thorough solution. That's the Oil and Gas Development Plan. It was created with careful consideration and thorough input from all stakeholders, including the industry. An oil and gas development plan would provide the necessary information for us, residents, and most critically, you, the ECMC, to determine if these proposed activities are in fact protective, as mandated, and whether the proposed BMPs are appropriate. We have a very difficult time assessing the effectiveness of these BMPs because we are not able to assess them through the lens of the necessary information. Normally, with an oil and gas development plan, we're given an opportunity for pre-application consultation. We can talk about, hey, how much maintenance are we going to need for our roads because of the increased traffic? What are the sound studies? Are these sound walls appropriate? Maybe, hard to say. Their waste management plan says that they can spread their drill cuttings on the field to the north. I don't think that's acceptable any longer. Of course, there's also cumulative impacts assessments, and most critically, alternative location analysis. Is Coyote Trails the best place to access these minerals? Are there other locations available to the operator that would be less impactful to our residents? I would say almost certainly, but we don't know that. Okay, moving on to Erie's position. Very simply, we would like you to deny these ADPs with the information provided. But denial is not even necessary. More critically, what we would like is for the consideration of the current and future ADPs or other Form 2 operations to require the submission of an oil and gas development plan, as well as forms 2B and 2C. Those to be considered by the normal public hearing apparatus, and then for these Form 2s and any subsequent Form 2s to be approved administratively as advocated for by the operator and as for provided in the rules. Because at that point, the Form 2s will be purely downhole considerations. And that was the intent of the rules. The intent of the rules as written is that there must be an assessment of the location and then approval of the Form 2s. Why do we feel this way? Well, we feel this way because this is what ECMC told operators would happen following the mission change rules. Again, just want to reiterate, requesting an oil and gas development plan, Form 2B and Form 2C is well within the right of this commission, as you may request any reasonable and relevant information necessary for you to make your determination. The following slides are verbatim the operator training that was provided by ECMC staff to operators in early 2021 following the mission change rules of the 200 to 600 series rules. The entire presentation is here so that there's no appearances that I'm cherry picking or taking things out of context, but for the sake of brevity, I'm going to whip through most of these. First, this is extremely applicable to Coyote Trails. This is what we're talking about in this slideshow. Procedural items here. Just a note that existing location review is being taken very seriously and will be thorough. So what are we considering? Obviously, we want to disturb minimal surface area. Next of consideration, called out specifically the Rule 604 setbacks. And thus, right here, we see that it was communicated clearly that any notion that only downhole considerations were relevant to a Form 2 assessment is completely dispelled. And the operator should not be under that impression because that was communicated right here that we're going to look at setbacks. We're also going to look at Rule 304 B2B. These are the alternative location analysis criteria. Of specific relevance to Coyote Trails is criterion 1. Again, is this within 2,000 feet from residential building units? Yep, couple hundred of them. And then criterion 4, is it within 2,000 feet from a municipal boundary? 2 of them. Does that municipality, does the proximal local government object? We do. We object most adamantly. Or do we request an alternative location analysis? We do. We request an alternative location analysis. When I spoke to the operator and brought to their attention that I was aware of Coyote Trails applications for permit to drill in August, I said, we are not in favor of further occupation, a third occupation of Coyote Trails, and we would like you to consider alternative locations. So our objection and our request for alternative location analysis was given to the operator over the summer. And then the last bit here is about the objective criteria review, which didn't exist in 2017. So then it was expressed what would be requested of the operator. New and enhanced BMPs, which we are very glad that they've decided at the 11th hour to toss into a sundry notice, which has not been provided on record to date. But we are grateful for those BMPs. Next, we have Rule 304B. That's the alternative location analysis. That should absolutely be requested here. And finally, you have Rule 304C, which are the 21 various and critical plans, including noise, light, transportation, water usage, a community outreach plan, cumulative impacts assessments. None of those have been provided. They are all absolutely critical in order to assess whether or not approval of this drilling is protective of public health. And it says explicitly right here. I mean, this is it. In some cases, a full OGDP application may be requested. If the case that there are 200 homes within the setback is not one of those cases, then I would tell you those cases probably don't exist. In fact, I would say this is one of those cases where ECMC should probably just outright deny the Form 2. Now, in case there was any confusion, a question was asked by an operator following that presentation. Hey, can you give us a little more information for when an OGDP will be required? And of course, staff said, this is not a catch-all, but generally look at these 2 things. Are there houses within 2,000 feet? Yes, there are. And second, the ALA considerations. Look at those 4 criteria. Are any of those 4 criteria met? Yes, 2 of them. This is a case where an OGDP is necessary and relevant. Additionally, as you'll see in the operator's presentation, as well as what was communicated to CDPH&E and ECMC staff, this is not 7 wells. This is 18 wells. They are proposing a single occupation for all 18 wells, and those 11 wells require new spacing. We see that the drilling and spacing application was submitted on October 25th, and the current hearing is noticed for February 7th, a couple weeks from now. In the operator training, permitting scenarios, again provided in early 2021. This is scenario 6 to a T, undeniably, unarguably. You've got a Form 2A predating January 15th, 2021. Check. You've got new spacing required for a well. You need a new Form 2. Then boom, right there, black and white. File an OGDP. File a Form 2B, file a Form 2C. Once those are approved, then staff will consider the Form 2. That's all we're asking for. Simply that what was communicated clearly to industry following the rulemakings, nothing new, nothing radical. What we are requesting is in fact the default course of events as communicated by staff. And it is the expectation that operators should have, and it is the expectation that residents should have, and it is the expectation that local governments should have. Please just direct staff to request an OGDP 2B and 2C. And then all 18 Form 2s can be considered for approval administratively, as that approval would just be for downhole considerations as intended by the rules. But Mr. Frank, isn't this unprecedented? Has this ever occurred before? Where in response to a Form 2, ECMC requested an oil and gas development plan. I give you well MSSU 30-8. This is about 6 miles north of Fort Collins in unincorporated Larimer County. Beautiful, beautiful country up there. You have a single well. The operator proposed a recompletion, an operation that they said would last approximately 10 days. So just for scale, we're talking a single recompletion on 1 well, not drilling 18 wells. As you'll see in Extraction's presentation, they think that their operations will last approximately 10 to 11 months, 30 times longer than what was proposed at MSSU 30-8, and obviously involving much greater impacts than a simple recompletion. What was the response?
Mr. Frank?
Yes.
Let me just interrupt. You're at closing in on 18 minutes. You were allotted 15.
Very sorry. I'll go very quickly.
Yeah, I want you to complete your presentation. I just wanted to give you that heads up.
I really appreciate that. I kind of lose track of time here. This is the full letter. I'm not going to read it to you, but the highlights, the take-home message is that a recompletion within 2,000 feet of several residential building units was deemed too impactful without a reassessment of this location, and that the rules require that in order to review the Form 2, an oil and gas development plan had to be approved. Finally, some implications here. How many coyote trails are we talking about? How many of these are out there? How many Form 2As, which were approved in order to foster oil and gas development, have undrilled slots, if you will? It's impossible for a resident to know if the oil and gas location adjacent to them could potentially be reoccupied. I reached out to ECMC staff to help me with my research, and I found that there are 4 other locations in or near Erie that have these undrilled wells. So just through extrapolation, this is probably an issue that affects hundreds of Colorado communities and countless Coloradans. There's also land use implications. We have reciprocal setbacks, 2,000 feet from any location where we're aware of a 2A where drilling could potentially occur. And until that Form 2A is either denied or drilling is complete, we can't allow the platting of residences or buildings that require occupancy to be allowed. How long do we have to hold these lands in hostage? How long do we have to tell landowners, I'm sorry, we can't plat your business, we can't plat your home because these wells could be drilled? It's obviously longer than 6 years. Is it 20 years, 100 years, forever? And finally, if we really consider these BMPs to be acceptable here, then you're throwing away Rule 604. You're saying, yep, this is the standard by which we would approve a new location within 2,000 feet of homes. Unless, of course, you accept the argument that Rule 604 only applies to new locations, in which case, what are we really protecting Coloradans from? It's this: dozers and scrapers. Can't be going out there and leveling a new pad. But once the pad's built, sure, this is fine. This is not the thing that Rule 604 was meant to address. It's this: dozers and scrapers. This is fine though. So in conclusion, the current rules established by ECMC require 2,000-foot setbacks from homes, except under limited circumstances. This rule was based on a mountain of evidence presented to this commission during the SB 19-181 rulemaking that well drilling has adverse human health impacts when located less than 2,000 feet from homes. The burden of proof lies with the operator, and that burden of proof has not been met because the location assessment was pre-181 and did not require that analysis. Thus, we implore you, please require a full analysis of the impacts, including cumulative impacts and alternative location analysis, be required. Direct your staff, please, to require an OGDP submittal along with Forms 2B and Forms 2C, and then look at these Form 2s. I'll leave you with a picture from Erie, from the Vista Ridge neighborhood, looking toward Coyote Trails. This is how close this is. These residents are relying on you to fulfill your mandate, to act in a manner that is protective of their health and well-being. Thank you. I apologize for going over. I probably could have spoke for an hour if I was allowed.
Great. Thank you very much. If you could stop the screen share, we'll have a chance for questions.
Of course.
One of the questions for the city and county of Broomfield, and I just want to give you the opportunity to speak to it as well. Can you speak to any changes in Erie in terms of residential structures or other land use developments that may have taken place since the initial occupation in 2024 that we find ourselves in now?
Sure. So this neighborhood predates the initial 2 occupations of Coyote Trails. So within 2000,
that's Vista Ridge?
Yes, Vista Ridge. So within 2,000 feet, there hasn't been a lot of significant changes other than a dramatic increase of traffic at this intersection. And that's because to the south, you have extensive development, not only of residential, but also commercial. There's a huge King Soopers down there, Children's Hospital down there, several other schools, et cetera, that were built. And it's hard to say if those developments would have been approved or delayed had the town of Erie not been operating under the very reasonable assumption that development activities at Coyote Trails had concluded at the end of 2019.
So let me follow up on that last point. So your testimony is that the town of Erie, its elected officials, its planners, et cetera, were under the assumption that as of 2019, the development at Coyote Trails was done.
Absolutely, because that's what was communicated to us by the operator.
Okay.
They said in all of their submittals, there would be 2 phases, an appraisal phase, and then up to 38 wells. Never was an occupation some 6 years later ever contemplated.
Okay. And let me ask a sort of a follow-up question, and commissioners, I'm going to get to you here shortly. Relevant to the Form 2s and the request for these some odd 18 wells, I can't remember exactly how many there are, was the town of Erie ever given any a particular notification concerning this advent of the asks for the Form 2s to be approved?
No, I routinely visit the ECMC website and just look for any filings around the town that could be of interest to me. I've had several cases where a spill notification slipped under my radar and was brought to my attention by residents. That's never ideal. So I try to be very thorough in review of any sundry notices, any other forms being submitted within 2,000 feet of the town, because I want to keep our residents as informed as possible of any potential oil and gas implications and impacts on their lives.
But that's a proactive act on your part. I'm asking if there was a proactive action on Civitas or Extraction to actually come to Erie and let them know about this new development on the Form 2s.
Never once. I brought to their attention that I had seen these Form 2s filed.
Okay. If the city and county of Broomfield officials are still around, I'd like to ask that same question of them. So hearings manager Thomas, at some point elevate maybe Ms. Gilbert, and she can answer that question for us as well. I think it's an important question. Even if Extraction and Civitas was under no regulatory provision to actually do the notice, I find it important to know whether they actually did that. So thank you, Mr. Frank, for answering those questions and for your testimony. Ms. Gilbert, did you hear my question?
Yeah, could you restate it again, just so I'm...
I just wanted to know if the city and county of Broomfield received any notice from Extraction Civitas about their desire to move forward with these Form 2s to drill these wells.
No, with respect to these 7 APDs, no, we did not receive any communication. We became aware of it through David Frank and Boulder and other jurisdictions who learned of it through, I believe, well, it's hearsay. I'll leave it at that.
Well, I think Mr. Frank testified that he kind of monitors things that are happening at the commission, and through that monitoring, he independently discovered the fact that these APDs have been filed for. And so then he alerted your community to that fact.
That is correct.
Okay, thank you very much, and appreciate you sticking around and being available for that question.
No problem.
Commissioners, other questions for Mr. Frank? Commissioner Messner?
Thank you, Mr. Chair. Thanks for the presentation, Mr. Frank, and good to hear from the town of Erie on this. You had a slide that I think tried to highlight kind of the evidence that Extraction had provided you information that they were going to be completed by 2019 at the latest. And I think it's slide 3 in your presentation, but I'm trying to figure out where that was pulled from. So it seems like there's a number of different things that were pulled from there. So
yes,
idea.
I'd be happy to walk back through that slide very, very briefly, and just say where these sources of information were from. I was moving very quickly, and I apologize.
Yeah, if you want to go ahead and screen share again, we can let you go back through that slide.
Okay. Okay. Trying not to repeat mistakes of the past.
We can see your slides.
Okay.
But that's not the slide.
Oh, this. So as I move through these, it was this bit, right?
Yeah, I think that's it. Yeah.
Yes. So yeah, these are just animation elements on one slide. So this is directly from the WOGLA permit issued by Weld County, stating that there would be 2 occupations, one in 2017, one in 2018/2019. These 2 pieces are from the transportation plan of that approved WOGLA permit. Again, stating very clearly that there would be 2 occupations, an appraisal phase and a development phase of up to 38 wells. So Weld County should be very aware that there were 2 occupations proposed and fulfilled. This is from the Form 2A. an appraisal phase, and the full development phase consisting of the remaining wells. And this is a condition of approval from that Form 2A. Again, saying 2 phases.
Okay.
Yeah, and I apologize. I whipped through that really, really quick.
No, it's okay. And actually, when I look at it in the packet, because it's got that animation, they're just kind of all on top of each other. And so it's good to have that walk through. So thanks for that. That's the only question I have.
Thank you.
Other questions for Mr. Frank? Well, you did a good job expressing yourself because we don't have a ton of questions, so we appreciate it.
I suppose so. Well, I'll be here all day. So if anything else comes up or any additional comments are needed from Erie, I'm more than happy. Thank you very much for your time. Very appreciative.
We appreciate the town of Erie's participation with us. We hope that despite not having received party status, that you were able to present the town's perspective to us.
It took me a little longer than the 15 minutes, so I appreciate allowing that slight additional extra time.
All right, great. Thank you very much. Speaking of the day ahead of us, commissioners, we still have a day ahead of us. We've got this matter and then at least 2 more matters. I'm inclined to take maybe a 30-minute break. Is that fair? Can everybody get a little bite to eat and get back here at what, 12:35? Does that work? Nodding of heads in the up and down direction. Let's return at 12:35.